position of having topics which are comparatively small. But of course, much depends on how much discussion there is going to be. In other words, if there are questions which require elaboration, then of course we can have a longer discussion. So feel free to raise any questions you have, make any points you want to make. Essentially what I'm going to do is to talk about two topics which are listed for today in the schedule, which are restrictions that can be imposed on journalists on grounds of national security on the one hand and parliamentary privilege on the other. So those are the two topics, two substantive topics we're going to look at today. What I also want to do is to go back to the part of our discussion on privacy which we could not complete, partly for lack of time and partly because we had a blackout. If you remember, I just begun to tell you about the Max Mosley case, which is quite an important case, when the lights went out, and therefore we could not complete that. And there are a few more points, thank you, which I want to make in relation to privacy, because I think that's an extremely important topic which all of you should be as acquainted with as possible. So I'm going to use the extra time available today to complete that topic. And then what I want to do is to, of course, give you an opportunity to ask many questions that you might have, because between tomorrow and the day after, which is our last day, I suspect we are going to be quite rushed. Tomorrow we have one big topic, which is copyright. And then on Friday, although the topic itself is not big, I suspect we will have a fairly lengthy discussion of various issues. So in those circumstances...
What's the topic, sir, on the last day?
Well, officially it is administrative restrictions on the media, which to my mind are just as important as strictly legal restrictions. But then I also have promised you, if I have the time, to deal with some cyber issues. In other words, online journalism, restrictions that can be imposed on online journalism, that sort of thing. So altogether we are going to have a packed program, there is no doubt about that. And then I suspect there will be a wrap-up which will require some time, and Shamik might want to say something, a sort of closing ceremony if you like, a very brief one. But it will all take time. So let us begin to assume that we are winding down, and therefore please feel free to ask questions about topics that may not have been dealt with, or clarifications about issues that have been dealt with in the last few days. I do personally feel sorry that everything has had to be so rushed, but that is in the nature of things. Most of the time we have these media law seminars or workshops running over 2.5 days at least, 2.5 days continuously at least, and that gives enough time for issues to be discussed at great length. But here we've had, for logistical reasons, to confine ourselves to 2 hours every morning, and it's not even 2 hours given that we began quite late most of the days. So that's where we are at the moment. I will also have occasion later on, if I have the time, to talk a little bit about what are the books that you can turn to for those of you who are interested in pursuing this matter further. I was hoping I would be able to give you some case studies, which sadly I think I will not be able to do. I have actually come prepared with case studies on all the major topics, but we just wouldn't be able to do that. So it is something we have to regretfully accept as inevitable. There we are. Now, before I start the topic, or the first topic of today, is there anything that you want urgently to ask me or tell me? No? Okay, in which case let's get going. What I have here is something on national security, which also, as I said, affects journalists from time to time. And really, the basis for restrictions that can be imposed on media people on this ground is threats to the security of the country. So, if there is anything that the media reports on or comments on that is likely to affect the survival of the nation, the integrity of the nation, then that would be legitimately prohibited and that or restricted, and that would be the basis for restrictions imposed on the grounds of national security. But it's very important to recognize that we are talking about the survival of the nation, not the survival of the government. There is a very big problem here because most authoritarian governments use national security as an excuse to impose restrictions on the media on the plea that the country is going to break up, so please don't write about certain things. When actually what they're talking about is the possibility of the government being affected, the government's stability being affected, or the government's survival being affected. And I do not have any hesitation in saying that this was the kind of argument that was used by Mrs. Indira Gandhi in 1975, and she spoke at great length and with ostensible passion about the breakup of India as a result of student agitations in Gujarat and the Jai Prakash Narayan campaign in Bihar and various other places, when actually what was at stake was her survival, her personal survival as Prime Minister of India. That is a kind of thing that needs to be borne in mind when we are talking about national security.
So generally, along with stability and integrity, another word we get to be given is sovereignty. You have omitted it intentionally, or that is superfluous?
It is not superfluous. It is simply that it is encompassed within these terms that we have been using. A threat to sovereignty usually arises when there is also a threat to the physical integrity of the country. Now, in theory, you can argue that it is possible for a country to lose its sovereignty without breaking up. I totally agree, and it is something that has happened in different contexts. Most of the time it happens by stealth. I can give you a very topical example in relation to what's happening in the UK. Many people very passionately believe that the UK has surrendered its sovereignty. But that is legal. It is not an illegal usurpation of sovereignty. And how has the UK lost its sovereignty or surrendered its sovereignty? Through membership of the European Union. So that British laws no longer have the force that they had before the United Kingdom became a member of the European Union, or at least before the European Union expanded in the way that it did and imposed its own will over the rest of the EU. Now that's a topic I don't want to go into. As it happens, I am going to address that issue at great length this afternoon at a faculty seminar. Now I don't know what the rules are whether students are allowed to attend a faculty seminar. Probably not. They can? Right. So if any of you is interested in that, you're very welcome. I'm going to talk about Brexit. I'm going to talk about the legal implications of Brexit, and that will of course involve a discussion of sovereignty in relation to the United Kingdom. So that is the context in which sovereignty normally arises. So if a foreign power tries to gain control over you, then you could say there's a loss of sovereignty. Another possibility is, and that I've heard sometimes referred to in the context of India by the leftists, is that by allowing globalization, India is at risk of losing its sovereignty because multinational corporations are going to rule India. That is clearly hyperbolic, but it is a viewpoint which people express, and they are fully entitled to express that viewpoint. So sovereignty is not something I want to stress in the course of this talk, because it is not that relevant to the media. It is relevant, but not all that relevant. Okay? And it doesn't matter what terms you use. Basically, what I'm trying to say is that the stability of the country or the survival of the country should not be mixed up with the stability of the government or the survival of the government. That's a very, very important point to note. And of course, there is a very high threshold for restrictions to be imposed on free speech in this area as in a number of other areas. Yeah.
So I will follow off, but sometimes the stability of the government is attached to stability of the country or the state itself.
Absolutely.
Like even the case is happening in Darjeeling right now.
Yep.
It is kind of interlinked
Yep.
to some extent. So then
Yep.
how do we draw a distinction?
Okay, very easy. If that is the case, your focus should be on the stability of the country, of the nation, rather than on the government. So they can impose restrictions, no problems at all. By extension, the government's position may be showed up. Possible. That's not a problem. But that is incidentally or coincidentally. But the focus of the restriction should be national security, not the security of the government or the stability of the government.
So even Indira Gandhi's matter,
Yeah.
actually it shows that it's for the country that I'm doing so and so, but it was for her government. So how, like that's where she was saved by this, like I would say, exemption. So like is there any possible way of drawing a distinction between?
Yes, there is. For a start, a vigilant media would very easily be able to bring out the distinction and educate the people. So, if you were to make the argument that what Mrs. Gandhi did was to save the nation rather than to save her own skin, then if the media were free, which at that time they were not, then the media would have a duty to educate the people about the distinction. That's one. In other words, public opinion will have to assert itself, which is exactly what is needed in a democracy. Secondly, there are other institutions, notably the judiciary. So, if a case went up to the court and the question was, is this law or is this executive action aimed at protecting the survival of the nation, then a judge within limits can strike down the law if that was not the case. In other words, if the law was blatantly aimed at protecting the stability or the survival of the government. And even in India, during the worst possible times, there have been judgments of the courts which have done exactly that. Namely, the courts have said during the emergency imposed by Mr. Gandhi that these particular measures are not needed to protect the state, to protect the stability of the state, and therefore they are bogus, and therefore they ought to be struck down. So it is possible, absolutely. And in some countries, judges have been very heroic and even struck down what amounts to the state of emergency. So when the state of emergency is imposed in a bogus way, it is possible for a court to say even the declaration of the emergency is, in legal terms, highly suspect. So there are ways in which it can be done. But my focus here is the media. So I want you all to understand that if you are faced with a situation where someone in authority tells you, don't write about something because national security is going to be affected, then what you should do is you should not ignore that. You should consider what is being told very carefully and apply your minds and see whether that argument or that proposition is correct. In other words, are these restrictions being imposed to protect the survival of the country, to protect the stability of the country, or are they being done to save the skin of the government of the day? And you have a choice. If you are true to your profession, if you're courageous, you would resist any attempts for restrictions that are unjustifiable being imposed on you. Of course, it's a price to pay for this because the authorities are not going to like it, in which case there will be probably retaliation from the government, and then of course you can't be sure what will happen. But I would suggest that to a certain extent you can rely on legal safeguards. In other words, you go to a court, and I would venture to say that there's a fair chance of getting justice. Now, I know that these things are a little unpredictable, but even so, the Indian judiciary is robust enough to protect journalists in those circumstances. So that would be the line I would take. Okay, so I was talking about the need for a high threshold in these matters. In other words, simply because there's a fear that eventually national security might be shaken is not a basis for imposing serious restrictions on the media. The threat has to be high enough, has to be serious enough for there to be restrictions imposed on the media. Also, it's possible for government to be quite smart about imposing restrictions and say, look, we are not going to impose blanket restrictions. In other words, don't talk at all about, as you said, the Gokha land agitation. That would be disproportionate and that would be unnecessary. What you can do is impose restrictions. What the government can do is impose restrictions that are intended only to meet the genuine exigencies of the time. And that's again a subject which is quite complex and where judgments have to be made, both by the people imposing the restrictions and by the media. And of course, there's a further twist to this, and that is, even where restrictions are imposed, it is possible for smart journalists to be able to, if you like, get around those restrictions. I'm talking of legitimate journalism. I'm not talking of yellow journalism, scurrilous journalism. Legitimate journalism, where you think that the restrictions are too wide. I personally think it is possible for you to get around those restrictions if you apply your mind carefully. And as I said, if as a result of that you are in trouble, you can hopefully get the help of the judiciary. Now, I cannot say any more on this because I realize I'm speaking the abstract. Now, we will have to look at this issue at greater length and in greater depth if we have the time by looking at particular situations. We sadly don't have the time for that, but all I'm saying is it's still possible for journalism to function within those constraints.
Sir, you have rightly mentioned about stability and integrity. I believe it will come in course of your presentation. Another thing which we suffer is in terms of law and order or maintenance of public order, MPO, certain restrictions are made like withdrawal of internet facilities and all. That might have not have any bearing on integrity as such, but sometimes for law and order or some administrative decisions.
I have to some extent dealt with it yesterday when I spoke about hate speech, because hate speech is usually intimately connected with public order. Not always, because as I said, there is also another dimension to hate speech, and that is the dignity of the individual. But public order is probably the most important reason why restrictions on so-called hate speech are imposed. But the other point which relates to your question is that there is often an overlap between public order and national security. They are connected, but there are situations where those two things can be kept separate. So keep that in mind. These are all very, very complex areas which, in the course of a 2-hour lecture is very difficult to handle. I do feel a little frustrated in not being able to give you the full picture, because if it was, for example, a seminar where I could discuss this topic for half a day, then we would be able to deal with it in the round, but we are not able to. So my apologies, but your point is very valid, that in terms of the overlap, some of the restrictions may be on grounds of public order, and some may be on grounds of national security. So today my focus is going to be essentially national security. Okay? Did you have a question? No. Okay. And of course, mere criticism of government policies is not enough. This, to a large extent, goes back to what I've been talking about. Namely, you are not meant to be restricted simply because you criticize the government and the government says that we will use national security laws to curb your tendency to criticize. Because the test is what is being said directly affecting national security? And as I said, the threshold is quite high. Not by saying it may affect national security, or in the long run it will affect national security. Sorry, that is not enough. You have to show what the American courts have called a clear and present danger. So if you show a clear and present danger in relation to what is being sought to be restricted, then that speech can be restricted. If that connection is not made, then sorry, the restriction will be invalid. Of course, who's the arbiter for whether it's invalid or valid? It is the judiciary. Ultimately, you'll have to go to the court if the government is not willing to listen to you. So there is that backstop which you need to keep in mind at all times. Now, sedition inevitably comes into the picture when you talk about national security, and it is in India quite a live issue to the extent that I've been able to make out. And it is contained in Indian Penal Code, section 124A. Now, what does it say? It is of course punishable with imprisonment for between 3 years and life, so it's quite a serious offence to be tried not in the magistrate's court but in the sessions court. And very briefly, the definition is that sedition is an act of bringing or attempting to bring into hatred or contempt the government established by law. Now, if you were to read that definition literally, you will think that a lot of what people write in the media amounts to sedition. Attempt to bring into hatred. It's quite possible that something you write critically about your government may make people hate the government in a very general sense. That's not enough, as I'll explain to you. Or contempt. You may feel contemptuous towards the government after reading an article that shows how badly the government is performing or how wicked the government is. But all that is not necessarily sedition. Or the excitement or attempt to excite disaffection towards the government by words, signs, or other visible representation. Now, you must remember that the Indian Penal Code is more than 100 years old. It was enacted in 1860. And the language used at that time is very different from the language that is used today. It is extremely unlikely if you had a law being passed today that those kinds of words would be used in the statute, particularly in a criminal statute. But at that time, the tendency was to use language of this sort, which is quite broad. Some will say overbroad. And do remember as well the context in which this law was made. We are talking of a colonial law, and the pressures that the colonial government faced were very different from the pressures that a democratically elected, free, independent country faces. So, given all that, it is not surprising that the language used is overbroad. And remember as well, incidentally, that section 124A was an amendment to the Penal Code. So it's not even something that was drafted into the Penal Code at the beginning. It was added on during British rule. So keep that all in mind, and then keep this definition in mind, only as a guideline.
Just to supplement what you just said, this section 124 capital A was used against Bal Gangadhar Tilak, and in Bal Gangadhar Tilak's sedition case, the court interpreted disaffection as something that engenders lack of affection for the government. It was very, very widely interpreted by the court. Of course, the standards have been lowered.
Absolutely. I think I have that case coming up shortly, but your intervention is very relevant, because that is what happens when you have an overbroad statute. And there is a lot of scope for interpretation by the courts. Just as a court can interpret a statute very strictly. A court can also interpret a statute very broadly.
So is there a subjective difference drawn between a negative opinion and seditious opinion, or is it objective? So how is a court going to work?
Can you give me an example?
So a negative, like if it's an article, it can be just my opinion that the government is not doing well.
Yep.
Now, where does it cross the line to a sedition?
Okay. As I will explain to you, you slightly jumped the gun by asking the question, but no problems. I'll tell you in very brief terms, and I'll elaborate when I give you cases. If you simply say this government is nasty, this government is very vindictive, this government performs very badly, etc., that is absolutely not sedition. Really what the essence of sedition is to say something disparaging about the government and then also to incite people into acts that are intended to overthrow the government by force, or at least not by democratic means. Remember, in a democracy, everybody has the right to advocate a change of government. And that inevitably means saying something unfavorable about the existing government, so that you say to people, look, this government is so bad that you have to replace it. That is totally legitimate, but replace it through democratic means. That is, when you get the opportunity, vote this government out of office. But if you said instead, this government is so bad, it needs to be thrown out, and you know what? Attempt a coup or a rebellion, a violent rebellion, or throw this government out through violent means. That would not be acceptable. That would of course be sedition.
The chances are there that a fair criticism can be used as an arm to destabilize the government.
What can be used? What can be used as an arm?
A fair criticism
Fair
can
criticism.
be used as an arm to destabilize the government. Then
Yes.
what is the problem? Then how we can fix up the responsibility to the author?
Okay, for a start, destabilizing the government is not an offense.
No, not in a democratic system or process.
Give me an
If somebody
example.
tried to use the article as an arm to destabilize government, destabilize the state.
Yeah, you keep repeating
Why?
the word destabilize. Give me an example. How do you mean? What do you mean destabilize?
Violent protest sometimes.
Violent protest, no problem. It is banned. It's not acceptable. But protest, peaceful protest in a democracy would be totally acceptable. So I would actually hesitate to use the word destabilize, because destabilization is an extremely vague word at the best of times. Inevitably, a government that is criticized feels that the criticism is an attempt at destabilization. If you are the government, you have to put up with destabilization, and the answer to that is you do things that will make people not destabilize you. You run your government well, how many people are going to destabilize you?
So right now, what you have said, we need to understand that incitement to destabilize the government in an undemocratic manner. That is the principal cause for sedition.
Quite clearly, a better word will be overthrow the government.
Overthrow.
Yeah.
That's exactly
Yeah.
it.
Yeah.
In an
I would
undemocratic.
be hesitant to use the word destabilize. No.
No, destabilize.
Overthrow.
I said overthrow.
Yeah. Okay.
In an undemocratic manner.
Yeah. And we'll try to tease this out when we look at more cases. So I've just begun my exposition of the law. Now, comments expressing disapproval of governmental measures with a view to obtaining the alteration of the lawful means would not amount to sedition. So even if you make very strong criticism of the government with the intention of bringing about change, as long as those criticisms are made by lawful means, they do not amount to sedition. Extremely important to remember, because as I will show you when I look at the cases, this principle has been lost sight of by many governments. Only those acts which have implicit in them the idea of subverting government by violent means would amount to sedition. Now that sort of gives you an answer, an alternative formulation to what you gave. So just see the words that the Supreme Court of India has used. Very, very important to remember. the idea of subverting government by violent means. So you subvert government not by peaceful means but by violent means. And that is, to my mind, a reasonably good standard to use when interpreting statutes like Section 124 of the 124A of the Penal Code. And this was the Kedarnath Singh case, which you must remember, it's a very important case decided by the Supreme Court of India in 1962. The dissemination of seditious matter is also an offence. Now this is important for journalists. Why? Because let's assume that you yourself don't do anything seditious. You're just journalists going about your job. But you have come across, for example, a pamphlet written by someone else which contains seditious matter. Now, on the one hand, you as journalists have a duty to inform the public, to educate the public. And it's part of your job to report matters of relevance, of interest to the public. But will you reproduce the pamphlet? I would suggest it would be risky for you to do that, because you are then becoming an accessory to the crime. Writing the pamphlet, if it is seditious, the pamphlet says, pick up arms and overthrow the government, meet at such place on a certain day at a certain time, and bring as many arms as you can and start firing. Now, if that is what the pamphlet says, it will be very irresponsible of you to reproduce that in your newspaper. So what you will have to do is, you still have to have a duty to inform the public. You can paraphrase and say that so and so has written a pamphlet which is seditious, and we do not wish to reproduce what is in the pamphlet, but it is a very disturbing matter, or something like that. That's fair enough.
Sir, in India, we face one problem, is that the outlawed or banned UGs, as we call underground outfits, they send press releases and they are quite relevant in a particular area, maybe in a state of the northeast or somewhere in GIAN, Chhattisgarh. But it is a practice that journalists do carry, not in the same language as the press release has had, but even not in the language which you immediately said that it is seditious and all. Might be this UG has called or fixed up a deadline to call for an armed revolution, etc., etc.
Yeah.
So we need to do it.
Yeah. In fact, I would clarify what I said. I should have said, not always do you characterize the publication as seditious, because you don't know for sure till a court rules on it. So it may be a matter of caution. What I intended to say was that it looks prima facie seditious. Therefore, we do not, only in some cases, not all the cases, therefore we do not wish to reproduce the contents of the press release.
So what I mean to submit is that it's a very common that we get that kind of releases,
Yes.
and we carry it.
Yeah.
He might be carried it in a greater depth, but I might be carrying it in a sober manner. But generally, it is carried.
Yeah.
Because
Well,
the balance between the
I
government
also
and the
heard
opposition.
from journalists that there are certain occasions and certain underground outfits which will cause you positive harm if you do not carry it. So in other words, you are really in a bind. On the one hand, you run the risk of being charged with sedition by the government. On the other hand, if you did not publish it, you are at risk of something else happening to you, as happened to a journalist in Bangalore last night, because you did not carry the news item. It didn't happen to her because of that, but all I'm saying is that kind of action is an ever-present threat for journalists. Yeah.
So, as you say, like when we are paraphrasing it, rather than saying it's a seditious pamphlet, just saying that it's a pamphlet which urges to overthrow the government or take arms against the government, is paraphrasing this much. Will it amount to an offence, or this is okay?
I think that's okay. It depends on, again, even that you'll have to refine your language a little bit.
Because the reader would want to know
Yes,
exactly why am I calling it.
Look, at the end of the day, there is still a lot of room for editorial judgment. So there is no standard formula to use in these circumstances. As long as you avoid yourself giving the impression to an average reader that you are advocating something that is illegal, then you're all right. So yes, absolutely.
So
Okay.
sometimes in Indian Parliament, what parliamentarians do that they produce some papers and say this should not be written.
Yes.
In this way, can journalists publish something and say that this must not be written in this manner?
Again, you're jumping the gun because parliamentary privilege is the topic I'm going to deal with immediately after this.
No. What I want to say that can journalists be the same way for publishing something which is coming from some groups like Noxalite or something like that. We got press release, publish it, and we write below we write a note that this must not be circulated or something like that. What parliamentarians do in parliament?
I have not quite understood what you're saying. You publish it and then you say don't circulate it.
No. As a note, we can say that this pamphlet must not be circulated among those people. But this language should not be used. We condemn it, but publish it.
To circulate a note to who?
To our readers.
That completely defeats the purpose of what you are
Actually,
trying
he tried to
to do.
mean that the newspaper published it with a tone of criticism.
That doesn't save your skin. That is not very different from having a disclaimer. I was telling you yesterday about the effect of disclaimers. Suppose you publish a defamatory article and then you publish a disclaimer saying it is not our intention to defame somebody. It will have no effect whatsoever because you have done exactly that. You have defamed somebody. So like that, you can't say I'm reproducing a seditious pamphlet and by the way, it is not our intention to engage in sedition. Sorry, totally unacceptable. That is the whole reason why I'm saying you should paraphrase it rather than publish it verbatim. Yeah.
Generally, sir, general picture is in most of the cases, this statement or press release by the banned outfit actually justifies the government action. That is my experience, I observe, and that's why the nationalist media publish it in the broader of their version, the extremist group or the banned organization versions, because it justifies the government action.
Yeah, I
Most
don't
of the
know.
cases-
Well, it's very difficult for me to comment on the motivation of particular newspapers. I'm simply telling you what the preferred approach should be to save your skin as far as the law is concerned. Ultimately, as I said, there is still room for editorial judgment. So the form of words used is largely left to the journalist or to the editor. Okay, let's move on. So dissemination of seditious matter is also an offence, and that is under a different law, which is the Code of Criminal Procedure, which we saw yesterday as well in relation to a different issue. Okay, there's a Bangladesh Tilak case to which Shamik referred to earlier, and in this case, there was a literal reading of section 124A, and what the court held was that forcible resistance to the government or rebellion against the government was not needed to make out an offence. So again, as Shamik mentioned, they interpreted the word exciting or attempting to excite feelings against the government in a very loose way, and also in relation to disaffection, meaning not engendering affection, that sort of a thing. So to that extent, this case has been criticized a lot. This was the Bombay High Court's ruling on a sedition case brought against Mr. Tilak. And interestingly, for those who are interested, there is a huge plaque put up outside the central courtroom in the Bombay High Court, in which are inscribed the words of Mr. Tilak after the trial, where he effectively says, there is a higher court than the court in which I was convicted, and I stand by everything I have said. In other words, being very defiant towards the court. And that was, of course, the subject matter of some controversy within the Bombay High Court a few years later. But essentially, this is what has happened. It's possible for judges to put literal construction on words. And if you did that, there is a danger that Article 1248 might be read restrictively against the media. And a similar construction was also put in another case, another pre-independence case, decided in 1946. Then, of course, you have the Kedarnath Singh case, which was decided after independence, to which I've already made reference. It is still considered to be a leading case on sedition. And here, what the court said was that successful prosecution needed the expressions of disaffection to be accompanied by an incitement to violence or a tendency to disturb public peace. And Section 1248 itself was held to be constitutional if read down in that way. For the benefit of those of you who are not lawyers, there are different techniques used by judges to interpret statutes, and one of the techniques is to read down a statute. In other words, if the words of a law are seen to be too wide, too generous, too expansionist, then a court can say, we are not striking down this law, but we will need this law to be read down. And that is what happened in the case of Kedarnath Singh vis-a-vis Section 1248. Now, I'll just give you a random list of cases that I've come across recently. Sorry.
So, kindly explain what you meant by read down. I'm sorry, something.
Suppose there is a law like Section 124A, which says that it is sedition to excite feelings of disaffection towards the government. Now, one way of interpreting that law would be to say anything that you say critical of government will excite in disaffection towards the government. That would be, in technical terms, correct. But it is equally possible to argue that what was meant was something more than simply criticizing government. So, what the courts can say is, whenever you interpret or apply Section 124A, do not read it literally, but read it down. Read it down to the extent that you impose a further condition that not only should it excite disaffection, but also that there should be some action that is violent and likely to overthrow the government. So reading down is quite a common technique. I would also venture to suggest that this can happen. I'm not saying it is going to happen, but it can happen in relation to Section 377 of the Penal Code. As you know, there is what in India is called a curative petition pending before the Supreme Court of India. Now, it is possible for the Supreme Court to read down Section 377 and say that we are not striking down this law, but we believe that this law should not apply to consensual sexual relations between adults in the privacy of their bedroom, etc., etc. It's possible. That's a technique that can be used. As I said, I don't know if the Supreme Court is going to use it, but that's an example of reading down.
So, in certain situations, when the opinions expressed are not really one that would ordinarily cause, like, dissatisfaction.
Distraction.
Or disaffection.
Yeah.
Sorry. But in a particular situation, causes say like a mob to riot. In that case, how do you, considering it was not objectively something that would have caused disaffection, but did in this particular case, and it really does affect public order, would you, and national security, what would be prioritized by the court? Is it just the fact, would they prioritize the fact that this should have, this was not objectively something that would cause disaffection, therefore we cannot charge it to sedition, or would we just look at the consequences and thereafter charge the
Okay.
Can I just supplement the question?
Yeah.
Say something like very objective criticism of the Indian Army in Kashmir.
Yeah.
Would that amount to sedition? No, maybe based on facts, maybe based on certain incidents. A very, very objective criticism of the army,
Yeah.
but the criticism is taking place, let's say, in the heart of Srinagar.
Yeah.
Would that amount to sedition?
The short answer to the question is no. A longer answer would be, you need to look a little more carefully at the criticism. What you call just criticism can sometimes be more than that, because there are a number of issues there. One is the actual content of the criticism, because people can make pretty damning criticisms or pretty dangerous criticisms in language that on the surface looks innocuous. Secondly, the context in which the criticism is made, the time when the criticism is made. If, for example, already Kashmir is boiling, that there has been a volatile situation, then even mild criticism may acquire a potency that such criticism may not have at other times. So there are all those qualifications, but as I said, the short answer to your question is no. So that is one thing. But your question is slightly different, and your question is actually very, very complex, even from the point of view of a sophisticated judiciary. Really, what you are trying to say is what happens in a situation which objectively may not amount to sedition does become seditious, in the sense that the consequences are quite serious. Now, I would suggest that a sensible judiciary will have regard to, of course, the facts of each case, and then see whether the reason why the situation went out of control had to do with poor law enforcement. Because if you're objectively saying anybody who did this in normal times would not have faced the kind of problem, or the country would not have faced the problem that has happened in this case, means that something went wrong. Now, what is it that went wrong? Is it the speech, or is it poor law order enforcement? It is a bit like I was talking yesterday about cases where some fanatics threatened to burn down cinemas. Now, the court has to take an objective view and say, if you say something like that, that does not amount to hate speech, and therefore we can't punish you. But still the situation goes out of control, the cinema is burnt down. It is not the fault of the speaker, it is more the fault of the law enforcement authorities.
So, like, what I want to ask more on the lines of the fact that even if they are rioting and a police force can stop that riot and send them home, the fact that these words did cause disaffection and cause them to start that riot itself is like a question of public order. Right? The fact that law enforcement agencies had to be dispersed to deal with the situation. So like on that comparison.
That is exactly what I'm trying to say. So you have to look, not you, but the judge has to look at whether the words were capable of the law and order problem arising in the first place, and that has to be an objective test. You know, the difficulty with many of these situations is, it is very easy to be wise after the event, and the judge does not have the luxury, most of the time, of knowing what will happen. A judge is faced with a situation where the government says, X has uttered these words, and these words are seditious. The judge has to apply an objective standard and say, and assess whether the words are capable in a normal situation, or at least in a situation that has been predefined, to lead to the consequences that the government says will ensue. And if the judge is of the view, before something has gone wrong, that will not happen, the judge will have to say, this is not sedition, we discharge this person. It is very rarely that you have a situation where something terrible happens and then the case comes to court. It can happen, but it's not always the case. Most of the time, the challenge is before the threatened consequences ensue. Okay, so that's why I said when I began my answer, it's very, very complex, but I still think a judge would apply what is called a reasonable standard, and a standard which generally maximizes freedom of expression. Generally, not an inflexible rule, but in a democracy you have to give a lot of freedom for criticism of the government, and that would be the approach taken in most countries. But remember, I can give you an easier answer, which may appeal to everybody here, and that is, if you apply the standard that is used in many countries, including under the European Convention of Human Rights, the questions that the judge will have to ask is it necessary in a democratic society. In other words, the restriction or the punishment that is being imposed. Secondly, proportionality, right? And thirdly, legality. Are the measures backed up by law? Now, theoretically, you could say that's not an issue because there is a law, the law of sedition. The real issues then will be necessity and proportionality, which are not very easy to talk about in the abstract. There are certain guidelines given, but you will have to ultimately look at each case on its merits. Okay.
So generally we see that along with sedition, waging war against the nation and criminal conspiracy, these two are also imposed. This is one I just wanted to share. Generally we see. And secondly, sir, would you like to deal sedition with UAPA?
Sedition with what?
The
Full form.
No, unlawful activities.
Unlawful Activities Act.
Okay, I have a feeling I have referred to it in the slide. I'll come to that. But you know, the point that you made earlier, which is true, fortunately, those don't concern media cases. They consider cases for non-media sedition accused persons, waging war, conspiracy, etc. I haven't come across too many cases against the media saying media are also guilty of not only sedition but also waging war and conspiracy to wage war. No, it is very rare. That's why, and again, you'll forgive me, but I have to be very conscious of the fact that I'm dealing with media law or law affecting media persons, not law generally. Okay, I can talk as much as you want about those things, but I want to be very strategic in the way I deal with the topic. Okay, right. So let's move on. So Kedarnath Singh's case is quite important, and a few other cases. Now they're completely at random, and in many of these cases, I don't even know what the results were. So I'm just going to give you the facts. You had the case in Ahmedabad involving the Times of India. Now this became quite a notorious case in the sense that there was a lot of public outrage over this case. There was a commissioner of police who seemed to have some sort of a grudge against either these journalists themselves, including the editor of the Ahmedabad edition of the Times of India, or against the Times of India, I don't know which. And so what he did was that when there were critical articles in the newspaper which effectively questioned this commissioner or his fitness to hold the office, then he slapped sedition charges against the journalists, which to my mind are completely untenable. Now again, it is possible that there may be more to this case than I have been able to make out. Because remember, I am dependent only on media reporting of these cases. I do not have the luxury of independent investigation. So please keep that in mind. And my view therefore is that if the media reports were true about the reasons why these journalists were hounded by the commissioner, especially with the charge of sedition, then it doesn't seem to make much sense at all. As far as I know, nothing happened to them. They were not sent to jail, and I suspect that the case or cases were withdrawn, or that the courts struck down the action. Then you have a case from Maharashtra where there was a magazine called Virodhi, which I suspect was very sympathetic to Maoists. Now, what this journal did was, there was an interrogation of a member of a banned Maoist group, and when the magazine published an interview with that person, then the editor was charged with, not charged with, but was at least arrested for sedition. I don't know whether charges were brought. So you can see the reaction of the authorities, but I can still understand why there was this action contemplated or taken, because if the organization is a banned organization and you go out of your way to interview a member of the banned organization, then of course there is a legal issue there. So maybe that's the reason why this prosecution was launched. And then there's a Lenin Kumar case from Orissa, where another magazine called Nishan what did it do? there was a book published, a Oriya book published, which described alleged persecution of Christian Adivasis, presumably in that state. And when this magazine presumably published excerpts from the book, then the editor of the magazine was arrested and sedition charges imposed. Again, I don't know enough about the facts of the case to be able to make a definitive judgment. If, for example, the book was genuinely seditious, that it said things which met the tough definition of sedition, then quite clearly the arrest of the editor would have been justified.
What are the legal issues about interviewing someone
from a banned organization?
Because the government jurisdiction itself can be very vindictive. Many fundamental organizations which are not involved in, so whether the press has a right to criticize that and put forward the version of the other side.
Well, again, it is not very easy. On the one hand, if an organization is banned with good reason, now with good reason can only be tested if it goes to court, then it is possible to say that carrying an interview with a member of that banned organization can have serious national security consequences. But not always, because it is possible even for a member of a banned organization to give an interview in which he doesn't say anything that is seditious. You know, for example, let us take an absurd example. You have a member of a banned organization, notorious fellow, whom you are interviewing in relation to his passion for cooking. It can happen. You know, there may be a chap who during daytime makes all kinds of threats, goes about with a gun, and in the evenings indulges in his passion for cooking, and is an expert cook. And you are interviewing only for his interest in cooking. I personally would not see that as remotely seditious or otherwise blameworthy. But I have a feeling, I have not seen this, so I can't be sure. I have a feeling that the notification which bans an organization probably says something about the fact that members of that organization should not be interviewed, etc., etc. It will be very odd. I personally can't see that happen, but it's not impossible. If that is the case, then in a sense you're breaching that order. You're not being seditious, but you're breaching that order. Possible. But a wiser way out of this problem might be to see if the ban is challenged in court, and if the ban is struck down, then you will be entirely justified in interviewing the person, to be very safe. But my short answer to your question is it depends on what the interview is about, not whether the person is a member of a banned organization or not. And I would imagine that a sensible judge will have regard to that fact. Okay? Right, let's move on. So that was the Lenin Kumar case. And then there was a case from Karnataka where all that happened was there was, the PUCL, the People's Union for Civil Liberties, which is a nationwide human rights NGO. I don't know how influential it is today. It used to be in the news a lot in the 90s and even 80s. Now the PUCL has or had an in-house magazine in which an article described alleged extrajudicial killings. As you know, extrajudicial killings have been the concern of many human rights organizations, including the PUCL, for many years. So they published an article, and a sedition charge was laid against the vice president of the PUCL. Now again, for lack of facts, I would be hesitant to say anything more about this case because I don't know what the content of the article was. If, for example, the content was also seditious, then of course there might be a reason for charges being brought. But otherwise, if it is simply the case that the article talks about concerns over alleged extrajudicial killings, then I think that should be allowed in a democracy. So you can see, you get a flavor of the kind of approach that the government has taken, or different governments have taken. Okay, Unlawful Activities Prevention Act, to which you made a reference. This makes it an offence to say, write, or do anything that is intended to bring about the cession of any part of India from the Union, or to disclaim, question, or disturb the sovereignty or territorial integrity of India. Now again, if you read this section literally, it means that you cannot question anything that is secessionist. Anything that is secessionist. But mere expressions of disapproval of government measures are not covered by the Act. In other words, if you say something critical of the government, then that law is not the law under which any action can be taken against you. Now, sorry, I forgot to say that in relation to this law, I think there was a case in Punjab, I can't remember the name of the case, wherein I think it was the Punjab High Court, it may have been the Supreme Court, I can't remember which, has said in proceedings that did not result in a judgment that even if somebody were to write an article advocating the secession of part of India, but through legal means, then that would not amount to an offence under this Act. For example, if somebody wrote an article saying state X should become an independent country, but it should become an independent country through democratic means. In other words, not only should people in the state agree, but also the rest of India should agree to it becoming an independent nation. And if that was the case, then that would not be considered to be punishable. Wouldn't be considered to be an offence. But as I said, I don't have any reference for that case. And this happened actually in the context of the Khalistani agitation. That much I remember, because as you know, some Sikh groups were advocating a separation of India, of Punjab from India, and of the creation of Khalistan. And the court had said, the court had actually dropped or struck down the prosecution of someone who wrote such an article after making it clear that what he advocated was a lawful means of bringing about Khalistan, not an unlawful means. So I imagine that if a case like that came up now, it is possible that the courts may take a similar view and say that freedom of expression allows you even to advocate the separation of part of India as long as you advocate it through legal, or you advocate it to happen through legal means.
You refer to legal means. Would asking for a referendum, would that be, would that come under the ambit of legal measures or not?
It would.
But there is no per se like mention of the word referendum in the Indian Constitution, or like, I don't know the other acts, but
Yeah.
as far as I know of the Indian Constitution,
No, there isn't. So the way it would work out is like this. If you want a referendum, you make the case for a referendum. In other words, you make a case for the law to be changed to allow for referendums to become part of the law. And then you hold a referendum. That is also totally legal. In other words, you are asking for an innovation to be introduced into the law, or a new procedure to be introduced into the law. That's entirely legitimate. Okay?
So one question. I mean, rest of India will never agree for Kashmir seceding from India. Would you say, is the qualifying remark like the article has to say that the rest of India also must do it by legal means? So suppose Kashmiris will want, I don't know whether all of them, but a section will definitely want to separate from India. So if someone writes an article only projecting or putting forward the views of a section of Kashmiris, because the rest of India will probably 90% will not agree. So what happens then?
Now it depends on how the article is worded.
And also, are there same responsibilities for a news story and an opinion piece on the edifice?
Okay, I'll get to the second question later. In relation to your first question, it depends on what the article is about. If the article says, as you suggested, that the writer would like, the writer says that some people in Kashmir would like Kashmir to be separated from India. If that is what the article says, I cannot see any problem at all, because it is simply reportage.
If the person advocates.
Now that's why I wanted clarity from you. If that person says it is my view that Kashmir should go out of India, right? Then that becomes advocacy. Now the next question to that will be, how does he want it to become as an independent state? Does he want it through lawful means or unlawful means? If it is unlawful means, clearly it is punishable. But if it is through lawful means, then I would argue that that would be legitimate expression of opinion. Okay, right. So let's move on. So it's important to note that simply because you express disapproval of government measures does not expose you or should not expose you to a charge under the Unlawful Activities Prevention Act. There's also something called the Police Incitement to Disaffection Act, which makes it an offence to commit any act which is intended to cause disaffection among members of the police force or to induce any member of the force to withhold his services. So this means basically that if you say, start a campaign to make policemen not listen to their superiors, now that of course would be punishable. Indian Post Office Act, these are all trivial provisions, but I'm just going to note that. Allows the government to intercept any person's mails on grounds of national security. Trivial in one sense, but it can have serious consequences, because if you are wrongly targeted and all your mail is subjected to scrutiny by the government, then of course you're not going to take it lightly. Though having said that, nowadays, because now very few people use what is called snail mail, maybe it's not of that much importance. You would probably be more aggrieved if the government were to intercept your email rather than snail mail. But the principle is the same. Indian Telegraph Act, incidentally, telegrams, as you know, have been completely stopped in India a few years ago. Again, the Act survives, 1885, allows the government to intercept telegrams and tap anyone's telephone on grounds of national security. The second is relevant because even though it's called the Telegraph Act, actions are taken under it in relation to telephone tapping. And there are quite a few cases which I will at the time deal with under the broad topic of privacy. Yeah.
So under the Telegraph Act, you need the magistrate's permission.
You need more than a magistrate's permission. You need the permission of a senior police official, first of all, to have a warrant for tapping. Yeah. There are safeguards. Don't assume. When I say allows the government means even a clerk in a government can go and tap someone's phones. No, there are safeguards. Okay. Customs Act allows, yeah.
But sir, in reality, what we see,
Yes.
the mobile phones are tapped like anything by
Yes.
any sub-inspector, by any inspector, because they have a control over the service provider, your location, your calls, and many of my colleagues have reason to believe that their calls are tapped.
I think all journalists who covered Maoist speed, all their phones were tapped. And
Right.
maybe tapped even
And we have
now.
every reason. We also know the signals by which we understand which call is being recorded and which is tapped.
I don't think I'll be revealing a great secret when I say that it will be a very foolish person who says anything confidential in a mobile phone anywhere in the world, because the extent to which there is general surveillance of mobile phone traffic is massive, and the potential nowadays for telephone tapping has increased so much that several million calls can be tapped at the same time. And remember, these are not necessarily tapped by a national authority. There are other authorities which also tap phones on a routine basis. Now, you can debate the rights and wrongs of it. There are some very good reasons why mobile phone traffic has to be tapped, including for India. I don't have the time to go into it, and I don't think it would be proper for me to go into it, but I am in possession of very significant information, first-hand information, which convinces me that a certain amount of, if you like, large-scale tapping is hugely beneficial for the security of each one of you. There's a lot of bad things happening as well. I'm not justifying telephone tapping on a large scale. I'm just telling you it happens. But the point you make is correct. In fact, actually, I would totally support you and say that there is a lot of disregard for the law in the matter of telephone tapping here. I remember even years ago, before mobile phones came into the picture, it was very common for a person who was interested in tapping someone's phone, not necessarily a government person, even a private party, for example, a commercial competitor, all they had to do was pay a very small bribe, 50 rupees or something, to what in India used to be called a lineman in a telephone company. So Calcutta telephones, Bombay telephones, whatever they are. And of course, telephones used to be a monopoly of the government in India until a few years ago. So you just slip him 50 rupees and the fellow will be delighted to tap the other fellow's phone for as long as you want it. But the difficulty with that is we are not talking about what is legal. So simply because a lot of illegal things are happening here does not mean that you disregard the law. It is my job to tell you about the law and not about how the law is disregarded.
So our point is something different. If a government agency does it, I mean, are they not required to take a legal action of doing so?
Are they doing it
or something?
Are they doing it according to you? The act you are complaining of, are these acts that are without authorization? Is that what you're saying?
Yeah.
Right.
I mean, I don't know whether a police authority has taken permission from the competent authority. There is a laid down rules that who is authorized to give permission for a telephone tapping. Now, whether the permission has been obtained or like a CCTV where a CCTV is fixed, it is said you are under CCTV surveillance. Then obviously the caller has to know. I mean that is his right. When we are talking about right, and when there is a law prescribed and the violation by the state agencies, my contention is this.
The great frustration I have in talking about these things is there is so much illegality happening in India that it is very difficult for me actually to either explain them or even give you a rational basis for understanding them. I think you're absolutely right, but the answer to that is very difficult because if you had a functioning legal system, by which I mean a legal system that is efficient, prompt in giving redress, competent judges, well-resourced, etc., this can be dealt with fairly quickly. But if you don't have that, where will you go? That is my question to you. So you're right. Although having said that, a few people, you call them brave or foolish, whatever, have gone to court about this. And in a few cases, they have got something like a judgment. Remember I was telling you about the PUCL case about 20 years ago. Now in that case, guidelines were drawn up for telephone tapping. And then there was another case which followed a few years later, which was brought by a chap called Amar Singh, a politician. There's a certain irony in the fact that he brought that case, and I won't go into that. But I'm sure some of you who know Indian politics better than me will appreciate the irony of that case. But anyway, in that case, as well, the Supreme Court made certain observations about how telephone tapping should not be allowed indiscriminately, etc., etc. So there are guidelines. Now, if people don't follow the law, what do you do? It's very difficult for me to answer
for us, it's very difficult to prove that my line is being tapped. There is no proof, but we know that it's being tapped.
Well, it is funny you say that because my answer to that will be, generally speaking, correct. But India is, I think I told you this in the context of my talk about freedom of information or something like that. That India is a funny country where, generally speaking, you don't get information if you go about it the legal way. But otherwise, you can get absolutely the most confidential information, including information about who taps your phone and at whose behest. You can get it. So, what do you see? I mean, I'm a little reluctant to talk about these matters because they are not legal, and it is not my job to encourage illegality. Okay, so we better keep it at that, you know. But you're right. There is a serious point. But my point in telling you about all this is at least for you to know that there is law which prescribes certain standards. And who knows, a few years from now, things may change. And at least those of you who feel strongly enough about these matters may want to confront authorities when the opportunity arises to say, sorry, but what you're doing is not legal. That is all I'm trying to say. Okay? Right, so let's move on. Customs Act allows the government to intercept and seize any imported matter that is in its opinion likely to affect the security of India or the maintenance of public order. Now, interestingly, this sounds a little innocuous, but actually this has been used a lot. You know in what context? Stopping the importation of issues of Newsweek. Why? Because it carries a map which is wrongly drawn. National security. Kashmir is not properly shown, or parts of China are improperly drawn, etc. Now the whole issue of the magazine is stopped. So if you are a subscriber to any of these magazines, you are denied the benefit of reading that issue simply because one line has been incorrectly drawn. So that is a consequence of the Customs Act. Here, Prevention of Terrorism Act, with which also you're familiar. I'm now going to talk about one or two other cases. The War and Peace case is about a man called Anand Patwardhan, who has got into a lot of trouble with the authorities, mainly because he is quite provocative, very left-wing fellow. What he did was he made a movie called War and Peace, and although it was certified by the censor board for public exhibition, this was a movie about the dangers of nuclear weapons, nuclear everything. And what he did was, when the movie was being submitted for censorship, among the cuts that were ordered were entire dialogues and visuals of the then Prime Minister, certain remarks by scientists who opposed nuclear weapons, and remarks by the Dalit leader expressing displeasure over the fact that the nuclear tests were carried out on Buddha's birthday. Might have been coincident, but whatever it is, they objected to it. That was sought to be removed, and also clips from the Telka tapes, which of course dealt with corruption. Now, all these were subjected to censorship, and the film was also banned from being exhibited at the film festival. Though my recollection is that Anand Patwardhan went to court and had these decisions reversed. So again, the courts have come to the rescue. I think this is mindless censorship, because quite frankly, if all those things had been allowed, very few people would have been even aware of what has happened. Now, because of the censorship, the film has become more popular than it did. So probably Anand Patwardhan should be grateful for what the censor board did in giving him and his movie additional publicity. Now, official secrecy, which is linked with the topic. Obviously, it has to do with transparency in government, but I don't think any government in the world will tolerate 100% transparency. It's impossible, because there are certain things which, by the nature of government, have to be kept secret. And so therefore, the question becomes, where do you draw the line? And that's where the contention most of the time is. And there is, I suppose you agree with me that there is a culture of secrecy within the Indian government. I'll be very happy if one of you challenges me on that. And of course, there's a very poor history of record keeping, which to some extent is the result, or is the cause for opaqueness. Because if records are properly kept, it's so much easier. Now, sometimes what happens is, a government servant may not be willfully wanting to deny you information. It is simply that it is so bothersome for him to locate the information because the records are not properly kept. So his instinctive reaction to your question will be, no, I can't give it to you. Not because he does not want to give it to you, but simply because it's too much trouble for him to go and fish for the information. So record keeping is very important. So what does the law say? You have the Official Secrets Act of 1923, which makes it an offence to communicate any information that's been entrusted in confidence by a government official to anyone who is not authorized to receive it. Just see, very broad provision of law. Again, it has to be read carefully, it has to be read with a degree of sagacity. The Act also makes it an offence to receive such information where the recipient knows or has reason to believe that it's communicating in breach of the Act. This applies to journalists in particular, because if someone gives you some information and you say, oh, I just took the information and I published it, that's not a defense if you're charged with an offence under the Official Secrets Act, because if you knew or had reason to believe that what you've got is in breach of the Act, it will be quite obvious in many cases. So if somebody were to give you a document which talks about India's nuclear strategy, then clearly it would be very naive to assume that this is a public document given to you which can be published. In those circumstances, of course, you will be liable under the Official Secrets Act. And the government, of course, has wide powers to classify information for the purposes of that. That is a matter of some concern, because every government retains the power to classify, but you cannot give the government blanket powers to classify. So, classification means that you give different types of information, different statuses. So you would have for your eyes only top secret, secret, etc., etc. Now that classification process is something which has to be done very carefully, and the criticism is that it is not done as carefully as it should in the various departments of the Indian government. Atomic Energy Act is another law which, generally speaking, you should be aware of. It makes it an offence to disclose certain kinds of information relating to atomic energy. Remember, atomic energy, not only weapons matters, atomic energy even for peaceful purposes. Very, very important to remember. For example, the location of design of nuclear installations, the research being carried out on nuclear materials, and unauthorized disclosure is punishable with imprisonment for up to 5 years and or a fine. That information is the flip side of the Official Secrets Act, to some extent. And I think you know more about this topic than I can conceivably imagine I do. So I'll still just go through the main points. Obviously, this is a law that allows you to seek information from public authorities. Very important to remember, public authorities. You cannot walk up to Infosys or Tata's and say, can I have information about this, that, or the other? This is confined to public authorities. It requires all public authorities to publish certain essential information about themselves. In other words, you don't make people ask for some kinds of information, you publish it yourself. What is often referred to in that horrible American phrase, so they are required to publish some information themselves. Also, all public authorities have to appoint public information officers. These are the contact points for the obtaining of information. But then, of course, inevitably, the law will have certain exemptions. So, some kinds of information can be denied. Information where it affects the sovereignty and security of India. Again, there's a lot of room for debate, for judgments to be made, where it is prohibited by a court or a tribunal, relatively easy to handle. Where it involves commercial confidence or trade secrets, again, it would be wrong to allow that kind of information to be given out. Where it is received with confidence from a foreign government, also very sensitive. Where it will endanger the life of any person or is to be kept confidential for law enforcement purposes. So if you as an investigative journalist went up to the police department and said, can I have a list of your informers, please? There is no way you would be given that, because it will threaten the life of those people. Where it involves cabinet papers, although in many countries cabinet papers are released after a certain number of years. So you have in Britain something called the 30-year rule. So 30 years after the date of a particular meeting, papers can be released. Okay.
Official document act.
Right. And where it involves invasion of personal privacy and is unrelated to a person's public functions. So you cannot go to a public authority and ask for information about a person's personal habits or personal affairs. So you can't, for example, make a FOI, RTI request to the Prime Minister's office and say, can we have details about the Prime Minister's marriage? I mean, that obviously is not relevant to his public functions, public duties. But the law very wisely has a section which says even if some information is exempted from disclosure, there is a possibility of the information being disclosed if the public interest is served. In other words, if the public interest outweighs the harm to any protected interest. So that's a nice provision to judge cases on their own merits.
So the example which you have given, it's not a personal information. He's a government servant or a public person. And in terms of his pension or what is his recorded marital status, it's a public document.
I didn't have that in mind. That would be a question that can be in certain circumstances
He's a
answered.
government servant. The private question is that how much deduction I make in my provident fund, but how much tax I pay and what the amount of my salary as a government servant, anybody is entitled to know.
No. What tax you pay is not information anybody is entitled to know. If, for example, you ask for details of how much tax Shah Rukh Khan has paid, okay, the income tax department will be totally justified in saying it is none of your business, get lost. But I know that what actually happens is from time to time the income tax department publishes lists of, there are two lists. One is of defaulters, people who have not paid taxes for a long time, and two of the top income taxpayers. Now, it just so happens that India does not have a Data Protection Act, does not have a Data Protection Act yet. If you had a Data Protection Act, that kind of a list would not be permitted unless permission was sought from the people who are named, which is very rare. So, I'm sorry to say that in the case of the Prime Minister as well, if you made a request about his pension arrangements, they would be justified in refusing you that information. Absolutely, no question about that. Because that is personal information of a kind that is not relevant to his public functions. Very important. Of course, there might be a law which is open to the public which says, there might be a law under which information is open to the public which says, these are the salaries of public officials like prime ministers, cabinet ministers, etc., and every person in occupying any of those positions has to pay provident fund at such percentage, pension fund, pension contribution at such percentage. All that is fine, but individual information can be denied.
But in an election,
Yes.
the candidates are asked to submit a affidavit with their financial status.
Yes.
And there we can find the total income and expenditure, tax, everything. Everything is there, even the bank balance.
What you have
Cash
said
in
is
hand.
absolutely
Maybe
correct.
the
In
statements
fact,
are wrong.
that is considered in
False.
many countries to be an invasion of privacy. Many of my Western friends express very deep surprise when they hear that you have these statements. And also, I will tell you about the judiciary. There is if you go to the website of high courts, you will find declaration of assets of judges. Now, in many countries that will be considered completely unacceptable. But I can understand the context in which it is allowed in India because of the large-scale either fears or actual experiences of corruption. So I agree, but on the other hand, somebody was telling me just the other day, probably a week or so ago, that much of the declarations that are made are under declarations, that very few people actually declare the full extent of their assets. So I don't know how effective it is, but each country has a right to have rules in that regard.
So people of India denied to do that for many judges.
Right. Yeah, but it's a voluntary thing now, and many judges have actually declared their assets.
Yes, but it's not mandatory.
Sir, I had asked you one thing about what are the rights of a journalist accessing some court documents
Yeah.
and whether
Yeah.
registries,
Yeah. Correct. Good question. The situation is quite complex. The way it works is there are certain documents which are available to the public.
Voluntary disclosure.
Sorry.
There is provision for voluntary disclosure of
Yeah, that is different. That we are now on the court documents. Okay. So, if for example, let's start with judgments. Judgments are totally accessible to anybody Now, a lot of the judgments nowadays are put on the website, so there is no problem. But some judgments are not. Now, what is the position with that? You will have to apply for what is called a certified copy of the judgment. Now, a certified copy, although you have a legal right to get it, is expensive because they have to actually type it, get it. Actually, nowadays they don't have to type it because it's on a computer.
Sure.
But in the old days, they have actually typed a copy, etc. So that's one. But you cannot legally access affidavits or pleadings, as we call it. Pleadings means documents in a case. In a case that is run by private parties or parties to a litigation.
Which includes exhibits also.
Of course, yeah. So, the answer to your question is some documents are public, some are not. And then the courts nowadays have an obligation also to publish certain kinds of statistics which should be open to everybody. So it's a mixed picture. Do you have any particular document in
I'll
mind?
give you an example.
Yeah.
There was a flyover collapse in Canada.
Yeah.
Last year March.
Mm.
So in all these months, the government hasn't yet made public a report that the IIT who gave them for all the status, whether it should be pulled down, whether it should be kept, whatever it is, no one knows it. I mean, there is not even. What we have learned is the government has given this document to this report has been given to the court. A court case is going on.
Yeah.
So can I approach the court for a copy of the IIT for a good recommendation or anything?
In theory, you can approach, but I'd be very surprised if the court gives it to you. Because
Legally, who do I approach? The registrar or
yeah, it will be registrar. Registrar. Never a judge. Always a registrar. Actually, if you want to be very technical, the court should have a public information officer. So you approach the public information officer. But I would be pretty sure you stand no chance of getting a copy of the document. I'll tell you why. Partly because it is pending litigation. In pending litigation, you cannot expect documents to be given out willy-nilly. Secondly, it may even be the case that the document has been given to the court in what is called a sealed cover. Very common thing in India, where I don't know why they do it, but some documents even the other side doesn't get access to in the litigation. So they seal the envelope and give it to the judge. So this particular report extremely unlikely that you get from a court, at least as far as the case is pending, as long as the case is pending.
another example I told when there was a Park Street rape case, the
Yeah.
charge sheet had been filed,
Yeah.
and the police officer didn't. So when the charge sheet has been filed with the court, can a reporter approach the registrar and say that I want to see what the police has filed?
You want to see what?
The charge sheet. What
The
is
charge sheet. The charge sheet normally is a public document because based on the charge sheet, the magistrate or the sessions court, depending on the gravity of the case, reads out in public the charges. So, without committing myself as regards Indian practice, I'm simply telling you that there is no reason why information on a charge sheet cannot be made public. How you make it public, I don't know, because I can tell you in my country what happens. That kind of document you can get straight away without any problems. But it may be that they will say, we can't give you a copy, but you can take down details. Inspection. Possible. At least I'll tell you that there is nothing legally for the information on a charge sheet not to be revealed, because a charge sheet is what leads to open discussion in court. When the accused person is brought to court, they read out the charge sheet. So you can get information, that's all, quite easily as a journalist.
Sir, actually we have our own, quote unquote, line man in the government department.
Yeah.
You know, and sometimes we manage to get government documents or information through those petty sources.
Yeah.
You know, to be straight, it's still information.
Yeah.
Still document. So what is the legality of publishing those documents or reported on basis of those documents?
Stolen documents. Yeah. You run a very serious risk. Okay, now I'm giving you the law. I'm not telling you what happens in practice. Okay, because I am very willing to accept that what happens in practice is very different from what is in law. So keep that in mind. I'll tell you legally what can happen. You will of course be liable under the Official Secrets Act if it is a document covered by official secrecy. Secondly, you will also be exposing yourself to a possible case of breach of confidence, for which you can be sued in civil law for damages. So there are two things here, criminal law and civil law. So totally risky. Having said that, if the document you have got illegally is a document of enormous public interest, where it reveals massive corruption or crime or anything like that, then you can still be prosecuted, but a sensible judge at the stage of trial will throw out the case against you, because he will recognize the importance of public interest. It is like a sting operation. Sting operations generally are illegal, but it is possible for public interest to justify a sting operation. So like that, it may be possible in given cases for the public interest to justify the publication of a leaked document. Yeah. Sorry, what Protection Act?
The Whistleblower Protection Act.
So can you speak up? I can't hear you. Whistleblower Protection Act. Yeah. Okay.
So it specifically excludes data
Yeah.
which are in the ambit of Official Secrets Act. So suppose like a government official who's placed in a like very high position, he accidentally discloses some data of like which is a part of the Official Secrets Act in a public conference. So firstly, can there be a reportage of the same? And secondly, can there be an op-ed piece on the disclosures that were made? Because, like, since the Official Secrets Act also prevents receipt of any information that are protected, so in that case, can like there be an opinion piece on those disclosures?
Okay. To answer your first question, the reporter will have to make a very close examination of the document in question and make reasonable inquiries to satisfy himself that the document has not been obtained in breach of any law, including the Official Secrets Act. If he comes to the conclusion after that reasonable inquiry that it is not, that he does not believe it to have been the subject of any restraint under either the Official Secrets Act or any other similar law, then his publication can go ahead, because he would have a defense of taking all reasonable steps. In other words, responsible journalism. Okay, again, depends on the judge. There's a lot of discretion given to the judge in these matters. So that is as far as that is concerned. The second question you asked was about comment. Now, comment, generally speaking, is not a problem, but you cannot, in the name of comment, cite material that should not be disclosed. So it depends on your skill as a commentator. If you're very smart, you can get out a lot of things without falling foul of the law. And I cannot give you a sharper answer than that in general terms, because everything will depend on the facts of each case. Yeah.
So the submission, that act which he referred to has not yet become an act. It's still an legislative process.
That's the reason I did not raise it at all. Yeah. Absolutely, yeah. So I'm talking about the current position, okay, which may change if the Whistleblowers Protection Act is brought in, okay. Right. Any other questions? Let's move on. I think we'll finish this quite soon. Okay, few cases under the Official Secrets Act. Very quickly, the budget case. I don't have to spend too much time. You know that the contents of the union budget or any government budget, is deemed to be confidential. And it is confidential till the time it is delivered by the finance minister. In the old days, the situation was that the people who print the budget papers were corralled into a room and kept there for a week or something like that. But now with mobile phones and other instruments, the situation must have changed. Although I did read very recently, in the context of the last finance bill in the Indian Parliament, I read that people are still asked to stay in a confined room for 2 or 3 days, maybe less than before, and that their mobile phones, etc., are taken away from them. So the position is that if anybody leaks any information from the from the budget, it is an offence under the Official Secrets Act, and that is what the budget case was all about. There was somebody who leaked such information, they were punished under the Official Secrets Act. The Sarah Tisdale case is an English case which has a point which I'll tell you in a minute. The case involved a lady who was working for the Ministry of Defence in London, and she had come across information, confidential information, marked confidential, about the sighting of cruise missiles in England. That is, cruise missiles, as you know, are American missiles which are based in England because of the defence cooperation between the countries. And Sarah Tisdale was a very passionate anti-nuclear campaigner in her personal life. Of course, it was ironical that she worked for the Ministry of Defence, but that's all right. She was just an ordinary clerk working for the ministry. And when she came across this document, she was, of course, thrilled because she thought this is a good opportunity of exposing the British government's plans in relation to cruise missiles, to which she was totally opposed. So what she did was she made a photocopy of the document and then left it in a brown envelope without any name on the front desk of a prominent left-wing newspaper called The Guardian. And in those days, the extent of surveillance was far less than it is today. So no CCTV cameras, etc. They would probably not have known if somebody left a document like that on the front desk, the reception desk of a newspaper office. Anyway, the Guardian newspaper was, of course, thrilled to get this document. They would otherwise have never got it. And so they published excerpts from the document the following morning. And sure enough, there was a very serious investigation conducted with the military police. And given how efficient the military police in our country is, they quickly zoomed in on Sarah Tisdale as the person who must have leaked this document. And to her credit, when she was confronted, she accepted that she was the person who leaked the document. Her defense was, and of course she was charged with an offense under the Official Secrets Act, which in many respects is very similar to the Indian Official Secrets Act. So when she was charged with the offense, her defense was that she did it for the good of the country. In other words, she did it in good faith. She passionately believed that nuclear weapons are bad, that cruise missiles will harm British people, and that she therefore wanted to sabotage the efforts of the government in proceeding with nuclear weapons. And that defense, of course, was not accepted because it is not a defense to a charge under the Official Secrets Act to say that I did it in good faith. You may have done it with good faith, but it is still an offense. So that's all there is for the Sarah Tisdale case. Spycatcher case, I'm going to skip. It's about a book that was published by a retired Secret Service man from England who, of course, had gathered many secrets in the course of his life. But what he did was he took the precaution of moving to Australia before he published the book, so that he was beyond the clutches of the British police. And he published the book in Australia. The book was widely circulated in all countries except the UK, where it was banned. And then, of course, eventually copies got into the UK, and the ban became a farce, and the ban was lifted. So today the publication is available to everybody. You can buy a copy of the book. In fact, I remember when all this happened, nearly 30 years ago, pirated copies of the Spycatcher were available on the pavements of Bombay in those days for 10 rupees, even before they were legally published in certain other jurisdictions. Now, the thing about this case is that if you are a member, if you belong to certain occupations, for example, if you're a member of a government security service, then you have a lifelong obligation of confidentiality. That obligation does not cease when you leave employment. You can't say, I don't work for the Secret Service, I don't work for RAW, for the Intelligence Bureau anymore, I retired so I can disclose whatever secrets I know. Sorry, that's not an option. You have a lifelong obligation of confidentiality, which you will have to respect. So your secrets will be taken to your grave. That is the principle that is involved in such cases. Iftikhar Gilani case, there was an attempted prosecution, or at least an arrest of an editor of the Kashmir Times for possession of a document describing Indian troop movements in Kashmir and blank Pakistani visa forms. These are actually things that arouse suspicion in the minds of the Indian authorities. I would say actually describing Indian troop movements is more a sensitive document than having blank visa forms, which nowadays, quite frankly, you can get on the internet anyway. Now, Gilani's defense was that the document had already featured in an article by him some years ago, having previously been published by the State Department, and visa forms are currently commonly kept by journalists who travel for professional personal reasons. And of course, when that fact came to be known, the charges were dropped. I think it's a case of somebody being over-enthusiastic, because if this information had already been published before by the US State Department, then quite clearly it is information in the public domain. And once you have information in the public domain, that cannot become the subject of a prosecution. Another case from Bombay, which is rather alarming. A journalist who was working for the midday newspaper in Bombay, he found in the main railway station in Bombay called Victoria Terminus a whole lot of newly acquired security apparatus just being kept on the floor. And he reported that instead of trying to investigate how that happened, they charged the journalist with an offence under the Official Secrets Act. Completely absurd, completely unsustainable, and not surprisingly, the charges were withdrawn because the government would have looked very foolish if the case went before a judge. There's a case which probably is from Bengal or at least or Assam, I don't know, where a journalist had reproduced the contents of a cabinet note which had been marked secret, but it was on the disinvestment policy of the government, not nuclear secrets or anything like that. The charge was held to be untenable because the disclosure had not affected the sovereignty or integrity of India or affected friendly relations with foreign states. And the court in this case also cautioned the government against going by mere classification of documents as secret. So it's an object lesson in saying don't mindlessly classify documents as secret and then start slapping charges under the Official Secrets Act against people who reproduce contents of those documents. There's also a slightly disturbing case about the denial of access to the papers of Mr. Aksar, who is, was very powerful. He was a bureaucrat under Mrs. Gandhi. To a journalist, A.J. Nurani. Nurani, as you know, is a meticulous journalist. He's a lawyer by training, but a good journalist. So when he wanted to do some serious research and went to the Nehru Memorial Museum where his papers are kept, they denied access to him, which is, again, completely bizarre and I would say unacceptable. After a fuss was made, access was granted. So you can see again how these things are done, not always in the best way they should be done. So there we are. That ends our look at official secrecy and other related matters, national security. Now, I was actually optimistic at the start of the class by saying it would be a relatively short chapter, but we now have one other topic to cover. I'll do my best, just run through it as quickly as I can. We still have officially about 10 minutes left, so you can bear with me. I will try to speed up. And relevance to journalists. So what we are looking at here is the clash between the legitimate interests of freedom of expression and the equally legitimate expectation on the part of parliamentarians that they will be given a lot of freedom to run their business without hindrance from anybody. And this has to do with historical developments over centuries when Parliament was not given the freedom to function in the way that Parliament functions today. Why? Because in the days of absolute monarchy, the king tried to browbeat Parliament. So we are going in history back to a few hundred years, to British times. And so subsequently, Parliament began to become very possessive of its interests, of its dignity. And that's what has led to certain rules being made on parliamentary privilege. So what are the legal provisions? We have the Constitution of India. There are 2 articles there which confer on Parliament and the state legislatures the powers and privileges enjoyed in the House of Commons at the time of India's independence. Slightly ironic, the law still keeps referring to the privileges of the House of Commons in London as a guide to the privileges of the parliamentary houses in India. This is important for journalists. The Parliamentary Proceedings Protection of Publication Act, which protects all substantially true reports of Parliament from civil and criminal liability, except when they are made with malice. This is like what we discussed in relation to the courts. You can publish fair and accurate proceedings of Parliament as well as you can of the courts. And if you say anything in it that is, for example, defamatory, you will not be liable because you enjoy privilege. There was a law previously in the same name that was repealed during the emergency and was reenacted. Cases, there's the case of Mr. Sharma, it's a 58 case which happened shortly after independence, where a newspaper called Searchlight published a report of a verbal attack in the Bihar Assembly against the Chief Minister. Now, what had happened was that the Assembly Speaker had, shortly after the attack had happened, ordered the expunction of the remarks, and yet the newspaper went ahead and published. Now, the newspaper tried to defend, after it was charged with breach of parliamentary privilege, that freedom of expression should prevail, because there was no specific order of the Assembly that the expunged portion should not be published. I think there would have been some doubt about this. Normally, of course, a speaker makes a very explicit order saying, I have expunged the following remarks which should not be published. I would suggest that if that kind of an order was not published, the journalist would probably have a defense if they took all reasonable steps before publishing.
Nowadays, we publish it and mention the speaker has expunged this portion. Because there is a provision in system in live telecast of parliamentary proceedings in Lok Sabha and Rajya Sabha. In Assembly, we don't have that system, but if anything speaker expunged, we publish and mention the speaker has expunged.
I see. Okay. Yeah.
Sir, there is a dilemma. Actually, technically speaking, whatever has been expunged cannot be reported. You have to say that at that point of time, such and such MP or MLA made certain statement which was expunged by the speaker for some reasons. This is actually has to be reported. But what my friend has said, now it is televised live. That's why in the newspaper we see the verbatim quote of the portion which is expunged, and then it is said that the earlier portion has been expunged. Now this, in one extent, a clear violation of parliamentary privilege, but this is going on in practice.
Okay, I can see the logic of what you're saying, though I think to some extent it is self-defeating, because the whole idea in expunging is not for it to become known outside. But on the other hand, you can't do much if there's live reporting, and there's no control of live reporting. One possibility would be, when the live reporting happens, if the speaker senses that there's going to be something said which will be expunged, he can ask the television cameras to stop rolling, or to do something that will not reveal what is being said. But there are problems. There are clearly problems. In any case, that's what you follow. So in this particular case, the journalist was convicted.
Or as you had mentioned the other day, there could be a live reporting with a slight time lag.
Time shift, yeah.
Maybe
Yeah, absolutely. Perfectly possible. But if that is not happening, then of course there is not much of a solution there. Yeah, sorry.
Another thing which we see in reality is, suppose a breach of privilege proceedings taking place, it goes to the privilege committee and the report of the privilege committee, that is being published by saying that what statement actually the person has made, which was expunged. So at the time of report submission of the privilege committee it comes, and then when actually it is tried, that means the person has been asked to stand on the dock and then the proceedings are being said. All those days, the statements which was actually expunged are being reported and reported and reported.
Of course, yeah. So that happens. I mean, it's something which, as I said, is in some circumstances inevitable. Okay, Keshav Singh's case was interesting. It's a landmark case on parliamentary privileges. A man called Keshav Singh wrote a pamphlet which was very disparaging of the members of the UP Assembly. Now, when that happened, the Assembly issued an order for breach of privilege against Keshav Singh. which it would have been well within its rights if there was sufficient cause. Now, what Keshav Singh did when he got this order was, instead of submitting himself to the jurisdiction of the assembly, he went to court and got an order staying the assembly's summons or warrant, it might have been. At which point the assembly became even more agitated and decided to pass an order of breach of privilege against not only Keshav Singh but also his lawyer and subsequently the judge who gave the order. So just imagine, provocation. So what the court has said is, okay, if you, what the assembly said was, if you don't listen to what we have asked you to do, then all of you, the alleged contemner, the lawyer for the contemner, and the judge who issued the order should all come before Parliament, which was seen as leading to a huge crisis. What then happened was there was a full bench of the Allahabad High Court, which convened to hear the case brought by the lawyer, the judge, and Keshav Singh. And the full bench also ruled that the assembly was not justified in calling these people to the power of the House. At which point there was a crisis, and a crisis that was increasing in intensity because there was a possibility that the assembly would have passed an order then, also implicating the 28 judges of the Allahabad High Court. But before that happened, the central government referred the matter to the President of India through what is called a presidential reference, which is possible under the Indian Constitution. And the presidential reference then was heard, and sorry, it's the other way around. The presidential reference was made to the Supreme Court. So the Supreme Court heard the case and had to decide whether the assembly was right in summoning these people for breach of parliamentary privilege, or whether there was any justification for stay of the order. And the presidential reference led to what looks like a judgment of the Supreme Court, in which the entire topic of parliamentary privileges has been discussed, and the Supreme Court has come to the view that the Assembly does not have the power in such circumstances to summon people like that, that there has to be enough latitude given for freedom of expression, and therefore such high-handed behavior on the part of the Assembly would not be proper. So that is the result of the special reference. There are a few cases. Now I'm very conscious of the fact that we're coming extremely close to finish time. Yes?
Previously, was it too clear the fact that since the Assembly is merely a legislative organ,
yeah,
I mean it should not form the function of summoning anyone to the Assembly?
No. The Legislative Assembly and Parliament both have the power to summon somebody to the power of the House. That is not an issue. The issue is the circumstances under which you do it. In other words, if, for example, the media is involved, then the question of freedom of expression comes in. So, there is no blanket ban on Parliament or Assemblies summoning someone to the bar of the House for breach of privilege. It has happened afterwards many times. Even now it can. But the question is, on the substantive content of the notice, are there justifications for such drastic action?
So why should it be Parliament and not the court of law?
Because historically that's how the law is developed. That Parliament has a separate power to summon and punish people. It is called Parliament sitting as a high court, if you want a technical definition of it. Parliament is given the same powers as a court, as a higher court, in this matter. Yes, I know it's an anomaly, particularly in a system of separation of powers, but it is an anomaly that has been preserved. And you see, I told you at the beginning that the powers and privileges of the Indian Parliament and state assemblies are exactly the same as in the House of Commons. And the House of Commons still preserves the power to summon someone and punish them for breach of privilege. obviously there will have to be some limits on that power, and that is what the presidential reference came up with. Okay?
Sir?
Yeah.
The judge can summon the speaker of the house.
No, no. A judge generally cannot summon the Speaker of the House. No. Because the Speaker is deemed to be autonomous within his house. Okay? Right, let's move on. Okay, I'm just wondering, since I can see the beginning of an exodus. Are the rest of you in favor of us continuing for a few minutes, or shall we defer what we have to look at until tomorrow? How many of you want to stop now? You got a class? No, be quite frank. You may want to eat something before you go. Yeah? I mean, be frank. I'm not going to be offended if you say we want to go just now. So, continue tomorrow?
Yes.
Yeah? Okay, in which case can I mean, this is a futile thing, but I'll still do it. Ask people to turn up early. Can you come 5-10 minutes early? We have got a lot of ground to cover. We have only got 2 days left. Okay? There's a little bit of this left, there's a little bit of privacy left. There's a topic for tomorrow, and then there's stuff for Friday. So please come if you can a little early tomorrow. Okay? Thank you.
Okay, and there's just